Hello guys. So this video I will start from Indian Evidence Act 1872. Indian Evidence Act stipulates how facts can be proved through evidence. Now you have to prove कि ये fact या ये चीज़ सच में हुई थी through evidence. ठीक है, through in record evidence you have to prove that this thing or this particular instance has occurred. Evidence Act helps judges to separate wheat from chaff and plays a crucial role in establishment of facts during court proceedings. What evidence can be admitted, how it can be admitted, how burden of proof has to be discharged, etc. are matters governed by Evidence Act. So Evidence Act is basically as a help for judges कि वो it is very important in the court proceedings for the establishment of facts on the basis of evidences. What type of evidence has to be admitted in this particular matter, how it has to be admissible in the court, how the burden of proof has to be discharged, and etc. all such matters. Main principles which form foundation of law of evidence are evidence must be confined to matter at hand. जो भी matter या जो भी situation है उसी के अराउंड वो एविडेंस होना चाहिए. हियर से एविडेंस सुनी कही बातें एडमिसिबल नहीं होंगी. उसने सुना था कि ऐसा हुआ, उसने सुना था कि इस बंदे ने बोला मैं उसको जाके मार दूंगा, तो ये सुनी सुनाई बातों पर कोर्ट यकीन नहीं करता. बेस्ट एविडेंस मस्ट बी गिवन इन ऑल केसेस. जो भी बेस्ट इन रिकॉर्ड एविडेंस हो वो प्रोड्यूस किया जाए, जो डायरेक्टली मैटर से रिलेटेड हो वो प्रोड्यूस किया जाए. इफ़ इट इज़ रिटन तो बहुत अच्छा होगा क्योंकि उसको बेस्ट एविडेंस की तरह ट्रीट किया जाएगा. लेकिन सुना सुनाई बात या कही सुनी बात नहीं होनी चाहिए. So that is one of the parameter of that what kind of evidence has to be admitted, right? One of the main objectives of Evidence Act is to prevent inaccuracy in admissibility of evidence and to introduce a more correct and uniform rule of practice. So one of the main principle or objective of Evidence Act is so that there is no inaccuracy, that how the evidences can be admissible or what kind of evidences can be admitted in the court, and there would be a correct and uniform practice which will be taken in all the times. Act is divided into three parts. Part 1, relevancy of facts or what facts may or may not be proved. These are dealt with in detail in sections 5 to 55. Part 1 is that what facts need to be proved and what facts need not to be proved. Part 2, how the relevant facts are to be proved. See, once in part 1 we have told that what facts need to be proved and what facts not need to be proved. In part 2 we are telling that how those facts need to be proved. The part deals with matters which need not to be proved under law and also how facts in issue or relevant facts are proved through oral and documentary evidence. So part 2 says that how the matters or the situations or the facts which need not to be proved, and it also tells that how facts or how relevant facts need to be proved through oral or documentary evidence. Evidence documentary evidence means जो कि written हो, जो कि document के form में हो, एक pamphlet के form में हो. Document is any written thing. तो कोई भी रिटन एविडेंस या ओरल एविडेंस किस तरीके से एडमिसिबल होगा और उसको कैसे प्रोड्यूस करना है, दैट इज इन पार्ट 2. पार्ट 3, बाय whom एंड इन व्हाट मैनर मस्ट एविडेंस बी प्रोड्यूस्ड. क्या एविडेंस होगा, पार्ट 1. पार्ट 2, कैसे उसको प्रूफ करना है. पार्ट 3, कौन उसको प्रूफ करेगा. It deals with procedure for production of evidence and effects of evidence. Confession, confess करना, मान लेना, admit करना. What confession appears for first time in section 24 of Indian Evidence Act. This section comes under heading of admission, so it is clear that confessions are merely one species of admission. As I told you, admit करना that yes I have or I haven't committed the crime. Confession में generally ये होता है कि जो accused होता है वो admit करता है, वो confess करता है कोर्ट के सामने कि हाँ हमने ये crime या ये offense किया था. Confession is not defined in Act. Justice Stephen, in his Digest of Law of Evidence, states confession is an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed that crime. So confession ज़्यादातर यही होता है that I have committed the crime. I haven't committed the crime, defense हो जाएगा. Confession is that I have committed the crime. It can be stated at any point of trial time by the accused person. जो भी चार्जेस उसके अगेंस्ट लगे होंगे उसको बताता है, ये इन्फर करता है कि आई हैव ओनली कमिटेड. सो दैट इज कन्फेशन. Admission and confession, sections 17 to 31 deals with admission generally and include sections 24 to 30 which deal with confession as distinguished from admission. So here we have a table which gives difference between confession and admission. Confession is a statement made by accused which is sought to be proved against him in criminal proceeding to establish the commission of an offence by him. So confession is a statement जो कि accused ने ही बोली है and then that statement is proved in the court to establish the commission of the offence. Admission usually relates to civil transaction and comprises all statements amounting to admission defined under section 17 and made by person mentioned under section 18, 19 and 20. So admission is generally it relates to the civil matters, not to the criminal matters, and it comprises of all those statements which are related to admitting the crime, admitting something that I have done this tort or whatever, since tort is also a civil matter. And whoever makes it, what kind of people can make admission statement, that is under section 18, 19 and 20. Confession, if deliberately and voluntarily made, may be accepted as conclusive of matters confessed. So confession, if accused has made voluntarily, अपनी इच्छा से और जानबूझकर वो बोले, तंग आके बोला है या अपनी इच्छा से बोल रहा है कोर्ट में, तो उसको बहुत ही सॉलिड प्रूफ एविडेंस की तरह माना जाएगा. Admissions are not conclusive as to matters admitted. It may operate as an estoppel. It may operate as an estoppel का मतलब है वो एक सपोर्टिव चीज़ हो सकती है लेकिन वो सॉलिड नहीं होगी. Confessions always go against the person making it. Obviously अगर मैं बोल रही हूँ मैंने क्राइम कमिट किया तो वो चीज़ मेरे अगेंस्ट होगी क्योंकि मेरे बोलने से वो चीज़ सॉलिड प्रूफ की तरह ट्रीट की जाएगी और मुझे वो क्राइम कमिट करने के लिए पनिशमेंट मिल सकती है. सो दैट ऑब्वियसली गोज अगेंस्ट मी, totally against me. Admissions may be used on behalf of person making it under exception of section 21 of Evidence Act. तो admission जो है can be used on behalf of the person who makes it. उसको यूज़ कर सकते हैं on behalf of the person who had made it. So confession against the person or admission may be used by that person who is making it. Confessions made by one or two or more accused jointly tried for same offence can be taken into consideration against the co-accused. अब जैसे 3 accused people हैं उसमें से एक accused ने माना कि हाँ हम तीनों ने crime किया है और वो केस उन तीनों के खिलाफ था jointly, तो एक बंदे की गवाही उन तीनों को फंसा देगी. Admission by one of several defendants in suit is no evidence against other defendants. तो अगर यही चीज़ बिल्कुल उल्टी है एडमिशन के केस में, अगर 3 बंदों के खिलाफ केस था, जॉइंट केस था, एक बंदे ने एडमिशन के लिए कोई स्टेटमेंट बोली तो वो बाकी 2 के लिए अगेंस्ट में नहीं जाएगी. Confession is a statement written or oral which is direct admission of suit. Written, oral कुछ भी हो सकता है. Confession. Admission is statement oral or written which gives inference about liability of a person making admission. So admission is oral or written document which gives that what would the liability of the person be who is making that admission. If conviction can be based on statements alone, it is confession. तो अगर सिर्फ उसके बोलने पर ही हमने उसको कन्विक्ट मान लिया क्योंकि वो वॉलंटली कबूल किया, उसने अपनी इच्छा से कबूल किया कि उसने क्राइम किया है, तो ऐसी जो स्टेटमेंट्स होती हैं दैट इज़ कन्फेशन. एंड वेयर सम सप्लीमेंट्री एविडेंस इज़ रिक्वायर्ड देन दैट इज़ एडमिशन. जहाँ पर एक एस्टोपल या एक सपोर्टिव एविडेंस चाहिए, एडमिट करने के बाद भी हमें कोई सपोर्टिव एविडेंस चाहिए उस चीज़ को प्रूव करने के लिए, तो दैट इज़ एडमिशन. Forms of an confession. Confession may occur in many forms when it is made to court itself. It is judicial confession, क्योंकि court judiciary के अंडर आ जाएगा. So when it is made in the court in front of the judge, that is judicial confession. When it is made to anybody outside the court, it is extrajudicial confession. Outside court, extrajudicial confession. It may even consist of conversation to oneself, which may be produced in evidence if overheard by another. अगर कोई A बंदा, if there is a person accused A who is saying that he had committed the crime to person B, and a person C hears that conversation, then that person C can present that I have heard it, or he may also record it in mobile phone or whatsoever, and he may say in court that I have heard these things. So that is also extrajudicial confession, because it is taking place outside of the court to another person, and if some other has heard it. For example, in Sahu versus the state of Uttar Pradesh, accused who was charged with murder of his daughter-in-law, with whom he was always quarrelling, was seen on day of murder going out of house, saying words to effect, I have finished her, and with her the daily quarrels. Statement was held to be a confession relevant in evidence, for it is not necessary for relevancy of a confession that it should be communicated to some other person. चाहे वो अपने आप से भी बोल रहा हो कि मैंने ही उसको मारा है, तो अपने आप से बोली हुई चीज़ भी confession हो सकती है. If it is outside of the court premises and the person is saying to himself that I have committed this crime, then that conversation with himself can also be a part of confession, and it can be a relevant evidence. Now, what was this case, Sahu versus state of Uttar Pradesh? In this, the person has killed his daughter-in-law. अपनी बहू को मारा था उसने, and they were always quarreling at all times. So at the day when murder took place, he was coming out of the house, he was going out of the house, and he was saying the words to himself that I have finished her. So अपने आप को भी बोलना, that can also be a confession. Judicial confessions are made before a magistrate or in court in due course of legal proceedings. Judicial confession has been defined to mean plea of guilty on arrangement if made freely by a person in a fit state of mind. Means अगर वो sound person है and he is confessing that I have made or I have committed this crime in front of a magistrate, in front of a judge, or in between the due legal proceedings which are taking place against him. If he is a sound person and he is making such statements or confession, then he will be held guilty on the basis of the statement. Extrajudicial confessions are made by accused elsewhere than in a court. It is not necessary that statements should have been addressed to any individual. It may have taken place in form of a prayer. वो भगवान से बोल रहा है, वो अपने आप से बोल रहा है. That can also be a confession, which is relevant evidence. It may not always be communicated to another person. It may be a confession to a private person. Extrajudicial confession has been defined to mean a free and voluntary confession of guilt by a person accused of a crime in course of conversation with persons other than judge or magistrate seized of charge against himself. Okay? For example, a man after commission of crime may write a letter to his relative or friend expressing his grief over the matter. This is also confession. Oral written कुछ भी टाइप का, अभी हमने वो टेबल देखी, oral written कुछ भी हो सकता है confession. Extrajudicial confession can be accepted and can be the basis of a conviction only if it passes the test of credibility as laid down in the procedural laws. So extrajudicial confession can also be accepted, can also be admitted in the court, and that can also be the basis that a person could be convicted for the crime that he has committed, if it passes the test of credibility which is laid down in the CRPC. Now, crimes under special and local laws. Certain acts are to be considered criminal acts even when they are not to be found in IPC. IPC में नहीं होते, but then too they are criminal acts. This is because they have been identified as crimes in special and local laws. An illustrative list is in the table. Now you can see these. Read it on your own, nothing to explain in this. Years के साथ दिए हुए हैं. So this chapter is complete. Next टर्न एडमिनिस्ट्रेटिव लॉ.